Macarthur Retirement and Lifestyle Presentation Series. Estate Planning with Rachel Stubbs.
Hello, I'm Rachel Stubbs, the Principal Solicitor of Rachel Stubbs and Associates. I've been asked to speak to you today about the legal aspects of estate planning. I've chosen 4 topics which I'll cover in fairly broad terms. Your situation will always be unique, so you'll find that if you're particularly interested in any of today's topics, your next step might be to obtain information more specific to your needs, which can be done effectively in a one-on-one forum. The first topic I've chosen to speak about is wills, something familiar to most people. Lots of people ask the question, should I have a will? I usually say to people, if you have assets, then yes, you want to make sure that what you have is left to the people you would like to see have it. A will deals with property, which is to say that you can only deal in your will with your property and your possessions. Lots of the time, people simply leave everything that they have to one person or one group of people, and they don't make specific provision for specific gifts. In most instances, we encourage people to nominate substitute beneficiaries, so that in the event something happens to their primary beneficiary, there is a second person or group of persons who step in to receive the benefit. When you're thinking about your will, you need to nominate an executor and a trustee for it. This is the person who's going to look after your estate. Sometimes it's one and the same person. Sometimes people draft their own wills. There are, however, advantages to getting your lawyer to do this for you. You want to make sure that your will is properly drafted so that it includes everything that you need it to, with no room for ambiguity so far as your intentions are concerned. A solicitor can take care of these sorts of issues and minimise the risk of problems arising down the track. The second topic is related to the first, and that is discretionary testamentary trusts. Testamentary trusts are essentially trusts within wills. They're used to give your beneficiaries flexibility, tax efficiency and asset protection. Essentially, instead of leaving an inheritance to a nominated beneficiary, as you would in an ordinary will, you leave it to a discretionary trust. This gives your trustee flexibility to distribute your assets in the most effective way. Discretionary testamentary trusts can give your trustee powers to split income. The trustee can then distribute income from an inheritance in a tax-efficient way. Trusts can also give your trustee an ability to avoid capital gains tax. Another reason to adopt a discretionary testamentary trust might be to secure some form of asset protection. For example, if there is a marriage breakup, by providing for a beneficiary's entitlement to be held in a testamentary trust, the beneficiary can isolate estate entitlements from personal assets and protect estate entitlements from family law proceedings. Assets can also be protected from beneficiaries who are insolvent. Because assets are held for the beneficiaries until the trustee elects to distribute such assets, they're not owned personally by a beneficiary and therefore do not form part of the beneficiary's estate. A creditor claiming against the beneficiary cannot obtain the assets held in the trust. Assets can also be protected against irresponsible waste by a beneficiary. The trustee can choose not to distribute to such a beneficiary, but be empowered to make a distribution if the person reforms. The third topic today is the power of attorney. A power of attorney is a document you can sign to appoint another person, called your attorney, to act for you in relation to your financial affairs. The document states what powers you give to your attorney, so it can be quite narrow and specific, say to act in relation to the sale of real estate, or it can be general, effectively allowing the attorney to step into your shoes. In some instances, you might continue to carry out your own transactions, but the attorney can act on your behalf as well. Alternatively, you might have the power of attorney signed, but hold on to it until you need your attorney to act in your place. You might appoint the attorney to act only for a set period of time, say while you took a trip overseas, or it can apply indefinitely. If you want your power of attorney to continue, even if you lose the capacity to make your own decisions, you need to sign what's called an enduring power of attorney. Additional requirements are necessary if you want your power of attorney to be an enduring one. It's important to carefully select your attorney. Any lawful action undertaken by your attorney is legally binding on you, so it's important that you nominate somebody that you trust. The last of today's topics is that of enduring guardianships. An attorney appointed pursuant to a power of attorney can make decisions on your behalf that relate to financial matters. An enduring guardian makes personal, health or lifestyle decisions on your behalf in the event that you lose capacity to make those decisions yourself. Again, you decide what functions you want your guardian to have. These can be specific if you want to have them make select decisions for you, such as specific medical treatment you should receive, or they can be more general, like power to refuse or accept medical treatment generally. Functions might also include where and with whom you want to live in the future. Again, you're best off discussing your specific needs with a solicitor, as this gives you the assurance that the documentation prepared includes everything it needs to in a clear and unambiguous form. What's been discussed here in today's forum is really just a broad brush overview of 4 topics that might be of relevance to you. There are many issues within the issues that have been raised in these topics that you would need to carefully consider before deciding what documents are important or necessary for you and what information the documents might contain. Although it might perhaps create more questions than answers, I nonetheless hope that it gives you a clearer picture of how these documents might be important to you and some direction as to where you might go from here.